Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near to give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning. Welcome to the Massachusetts Appeals Court on this Tuesday, March 25th, 2025. Normally I go through a little spiel about the clock, but that doesn't seem necessary here. Normal rules apply even though we're starting at 11 or almost 11. With that, I will call the first case. Oh, I should introduce the panel. I'm Judge Ditkoff. To my right is Judge Han, and to my left is Judge Walsh. I'll call the only case we're hearing today, Commonwealth versus PARVARESH, number 23P 1494. Whenever you're ready, Counselor.
Good morning. May it please the Court. Lisa Kaur on behalf of Mr. PARVARESH. I would like to take my time this morning to address two issues briefed. One, the prior bad acts, and second, the ineffective assistance of counsel based on the failure to engage an expert. Going to the prior bad acts first, I'd like to draw the Court's attention to the fact that defense counsel objected to this evidence. First, during motions in limine, second, even on the morning of trial when he raised the issue again asking for clarity, and then third, when the evidence came in at trial. And I expect the Commonwealth may suggest that the evidence that was admitted wasn't the most, offensive or particular evidence, and that in light of everything else that came in, there wasn't prejudice to Mr. PARVARESH. But I would ask the Court to consider some of the more recent cases that were issued after I filed my brief. I draw the Court's attention to Fernandez and Samia, and in those cases, the Court emphasizes, again, the particular care that has to be given to prior bad act evidence. In this case, the trial judge...
Could you give us a 16-0 letter with those?
I have not, Your Honor. I will.
Well, could you give us the citations?
Yes, Your Honor. Samia is 492 Massachusetts 135. It's a 2023 case. And in that case, the SJC said that they were taking this opportunity to emphasize the importance of specificity and precision in the context of ruling on bad act evidence. In this case, Judge Orfanello admitted the evidence for the purpose of, I think, on the issue of the victim's perception of the relationship. That was the stated reason. And I know that it's often cited that a hostile relationship between the parties is a permitted purpose. When you look at the cases that are cited for that proposition, including, when you look at the cases that are cited for that proposition, there's often an accompanying issue, like the defendant's intent. So I said in my brief that the purpose of this was, and I think the Commonwealth described it as dubious. I don't know that the relevance of the victim's perception of the relationship is particularly relevant when you weigh it against the prejudice of the admitted evidence. And I think that the problem in this case was that the judge failed to mitigate the prejudice of the admitted evidence with a contemporaneous limiting instruction that was clear to the jury, and also you'll see that there was no final instruction addressing prior backed evidence. And Samia also, I think, reiterates the point of the importance of the clear contemporaneous instruction and the final instruction as mitigating the potential prejudice to the defendant. Well, it's not even potential prejudice. I think the cases say that prior backed evidence is inherently prejudicial, and so what must be done is a balancing of the probative value against the prejudice. And I don't think we can even really tell what the judge did in terms of balancing from the transcript in this case, whether there was that balancing where she didn't really articulate the value or the probative value of the evidence against the prejudice to Mr. PARVARESH. So I would ask, in light of what I've briefed and I think the renewed emphasis on the care that should be given to that type of evidence, I would ask the court would find that the admission of that evidence was both error and prejudicial error. Turning to the issue, if I might, of ineffective assistance of counsel. Judge Coven, during the motion for new trial and in his decision, which I think is in the record appendix at 105 and 106, Judge Coven wasn't the trial judge, and so the trial judge had retired at the time. And I would say that he was potentially at a disadvantage of not knowing the facts as well as the trial judge might have. But he, I would suggest, I think, minimized the weight of importance of the abrasive injuries that were on the victim's neck. The judge found in his motion for new trial that the appearance of the scratches, or the scratches themselves, weren't dispositive of the charge of strangulation. And Judge Coven also raised during the hearing, and the Commonwealth responded, that he was concerned about creating a rule that would require district court practitioners, who I think commonly encounter these kinds of cases, to engage an expert, otherwise face an accusation of ineffective assistance of counsel. And that the case law is primarily focused on previously shaken baby syndrome or sexual assault type offenses, and not more common offenses where you see these types of injuries.
So I'm having a hard time understanding how this doctor's opinion is helpful, because the nurse sees the red marks as soon as she comes in. The officer sees the red marks at the time, and what's the woman's name?
Ms. Coughlin, sorry.
Ms. Coughlin says she never sees red marks at any point. So, I mean, it seems either the officer's telling the truth or Coughlin's telling the truth. I don't see what the doctor adds to this.
So I think I would agree that there are questions. Both parties, the Coughlin and the officer, denied seeing red marks outside, and everyone agreed that the lighting wasn't good. What the officer, I think, what could have been emphasized, and what I would emphasize today, is that the officer didn't recall whether or not the victim went into the bathroom. Coughlin testified that the victim went into the bathroom. When she emerged, she had red marks. I think she described them on her chest, scratches on her chest.
Right, but says that there were never marks on her neck.
Correct. So the officer describes marks, seeing red marks on her, I think on her neck and on her chest. He, though, doesn't have, I think it's not clear from the transcript, and it wasn't really emphasized at trial, at what very point in time in the house. So he doesn't remember that she went into the bathroom. The victim herself testified that she went into the bathroom, and Coughlin said that these abrasive injuries or red marks appeared after she came out of the bathroom. I think that the reason that the medical expert's testimony is helpful is because if you credit the clear memory of Ms. Coughlin of the marks appearing after she comes out of the bathroom, first of all, the defense attorney may have been better able, as I think the case is emphasized, to cross-examine even just the officer about the timing of the marks and when he specifically saw them. But what the medical expert's testimony is important to show is that they appear almost instantaneously, that they're the type of abrasive injury contrasted with, say, a bruise or a contusion that appears within a minute or less of infliction of the sort of method of injury. And so he admittedly relies on Coughlin's testimony to form his opinion, but without that opinion, you're left with I think you're left with trying to contrast Coughlin's testimony at trial with the police officer's testimony.
But are you really, I mean, on the one hand, it seems as if when you read, is it, how do you pronounce, is it Klauke? I don't want to miss.
Klauke.
Klauke?
Yeah.
Okay. The doctor's testimony, or affidavit, one point is that these injuries were not defensive, right, injuries, which wasn't a theory in the case.
No.
Right? And then the second is about timing of scratches, which even the doctor appears to admit that this is something that most people can understand, and that there isn't robust evidence in studies, kind of timing of abrasions and when they would appear and when they wouldn't appear. So how does this really help you when it was otherwise always a strong kind of position and a central position of the defense that he didn't do it and that she inflicted these injuries upon herself?
Well, I think there are other aspects of his affidavit that I would draw the court's attention to, including that these sort of parallel lines he opined came from sort of multiple paths or raking motions across the neck. And she testified that she felt his nails when he released, she specifically testified, he caused those marks, I did not. I felt his nails when he released my neck. I think what was never said out loud or specifically was that these marks on her neck are consistent with someone dragging more than once their nails across an individual's neck. The reason I think that the opinion evidence about the timing and appearance of the abrasions is important is that there were similar abrasive injuries to her forearms, which she testified at trial were caused by the defendant by a fork on each arm by him dragging this fork across her arm. When you look at the photographs of the sort of fork abrasions and the nail abrasions, they are similar in appearance and character. And so when you have the jury hearing testimony where she specifically attributes those injuries to a sort of method and an instrument, same way she did with the neck, but they discredit it or did not find that it had been proven beyond a reasonable doubt as to the forearms, I think it's a comparison that was missed at trial to say, you should not credit this testimony about the forearms and the fork. And in the same way, where she specifically alleges that these scratches were created by Mr. Parvaresh when he released her neck, they're similar in appearance, they're similar in timing, and they're also a similar, I would suggest, although, Judge Coven's correct, it's not necessary that someone has scratch marks to prove as evidence of strangulation or to prove strangulation. But where someone testifies that these were caused as part and parcel of that action, I would suggest it's arguably exaggeration or fabrication to sort of sell that infliction of injury. And that's why I think that's important.
On your claim of ineffective assistance of counsel, if I read your brief correctly, and correct me if I'm wrong in my interpretation, it's both the failure to investigate and then call a medical examiner?
Well,
or is it really? So
I think the cases, and there are, Commonwealth v. Gill, I didn't cite in my, and I will forward a 16L letter, but Commonwealth v. Gill is a 2020 Mass App case, 97 Mass Appeals Court 114. It's unpublished. But in that case, the court found that there was no ineffective assistance of counsel where the issue was a self-inflicted, whether something was a self-inflicted injury. There was a knife fight and a machete, and the defense attorney, though, engaged an expert and consulted with that expert. And so because there was that consultation and engagement, but the court could determine that the decision not to call the expert at trial was not manifestly unreasonable because there was a tactical decision made. In this case, there was no engagement of an expert, and I think that Barron, 74 Mass App at 256, 2009 case, talks about permitting the defense ceding this advantage to the Commonwealth by permitting them to essentially be the purveyor of expert witness evidence. Now, the nurse was not technically an expert witness, but she certainly came to court with credentials beyond what the defendant presented. And the cases that talk about preparation and investigation suggest that even if counsel decided not ultimately to call that witness to testify at trial, the opportunity to be better prepared and counter the Commonwealth's evidence on the scratches, because what he did instead was make a lot about the timestamps in the medical records between the doctor's observations and the nurse's observations. I don't think that was particularly effective. I think that the nurse was quite clear that she saw these marks when when the victim presented herself at the ER, and they were photographed. So making a stink about when the doctor saw what he did or didn't wasn't particularly effective, contrasted with having a medical expert to say, well, these marks are not likely to have been produced at the time of the incident she alleges, but sometime subsequent to it, would have been, I think, important evidence for the defense. And the failure to present that evidence can't really be described as a reasonable tactical decision without having engaged the expert to inform that decision.
Isn't that the rule that Judge Coven was concerned about creating?
Well, I think Judge Coven focused on, and I would say it's not necessarily a rule, because it depends on the facts of the case, it depends on the theory of defense. So if you look at, at Gill, it's not a sexual assault shaken baby case, it's about sort of a melee with whether something was self-defense or accident. And so I don't think it's creating a rule, it's respecting the fact that each case falls on its own theory and facts.
All right.
Thank you.
Thank you very much, Counselor. We'll hear from the Commonwealth now.
Morning, Your Honors. May it please the Court, Caleb Schillinger for the Commonwealth. If I may, I'll pick up with the ineffective assistance claim in that issue. And I think the crux of the issue is exactly what you asked, Justice Ditkoff. What does this add?
Doing well today.
Hope I can say the same. How does it move the needle in this case? And I don't think that it would have moved the needle. The expert's analysis, as I think of it, essentially boils down to a two-step way of thinking of it, which is Coughlin didn't observe any scratches on the victim's neck at any point. And in my experience, abrasions typically appear quickly, within perhaps a minute, a couple minutes. Therefore, this couldn't have been consistent with the strangulation event, or the scratches being inflicted during the alleged strangulation event. But of course, the jury didn't have to credit Coughlin's testimony. And what stands out to me is that nothing in Dr. Klauke's affidavit or the testimony he might have proffered, or an expert might proffer, goes that next step and says, for some other independent reason separate and apart from Coughlin's testimony, these scratches could not have been consistent with being inflicted at the time of the alleged strangulation event. Were there testimony to that effect? Perhaps it could have aided the defense here, or might have had some significance, but that's not the testimony being proffered now. Separate and apart from that, I think on the issue of there being multiple rakings of fingernails, I would just note for the panel that the victim did testify she could feel the defendant scratching her, both as he was holding her neck and when he released his grip, which could be consistent with multiple rakings of the fingernails. As to the issue of perhaps a failure to investigate, I would note, I guess Justice Walsh, I struggled as well to understand if that was sort of the scope of the claim. Obviously in the briefing I focused on, the issue of what impact this would or would not have had in terms of the overall evidence of the case. But with respect to investigating specifically, I would just note that trial counsel's affidavit doesn't really address that point. Yes, he does say that he did not engage a medical expert to review the medical records or to testify, but he doesn't indicate, for example, did he informally consult with a medical expert on this issue, or did he do some other research or investigation to make a determination whether it would be worth going the next step to engage an expert. And I would suggest, in any event, given the nature of the injuries that we're talking about here, scratches, which again is well within the knowledge of a layperson, and the other issues, it would not be manifestly unreasonable for counsel to look at this scenario and say, I think that I can make the points that I need to and present a defense effectively through Coughlin's testimony, through the medical records, and perhaps cross-examining the nurse on the timing of Dr. Lofel's examination versus her examination, and the fact that his provider notes don't make any mention of marks on the victim's neck. So for all of those reasons, I would suggest that the absence of the proffered testimony here would not have materially aided the defense that was presented. It certainly didn't prevent the defendant from presenting the defense. He did so, and very effectively, I would argue, and therefore does not rise to the level of ineffective assistance. If the panel has any questions on that, if there's anything I could address, it would be helpful. Otherwise, I'll switch and just briefly address the prior bad acts. And on that, I may have read Samia when it was issued. I have to admit I can no longer remember any discussion within that case relating to prior bad act evidence and the instructions to be given. I did review the final charge right before argument. I believe counsel is correct. I didn't see, in looking through that quickly, the judge reiterating the limiting instruction as to the prior bad acts evidence, but would suggest that the
It was kind of an odd limiting instruction, don't you think? I mean, you'd think that it'd be limited to the nature of the relationship, not the perception of the nature of the relationship. I've never seen that before. Am I missing something?
You're not, Your Honor. I have not seen that either. What I would say in response is, if anything, it was less prejudicial to the defendant than it might otherwise have been. The judge could have given a limiting instruction that the jury was able or permitted to consider that evidence as evidence of the existence of a hostile relationship. Instead, she limited it further and allowed the jury to consider it only as to the victim's perception of the existence of a hostile relationship.
It's almost a cross between state of mind evidence and prior bad act evidence. It appeared when reading it to me, but.
Yes, and I think that it was perhaps an effort by the judge to further mitigate any potential unfair prejudice to the defendant in making it clear to the jury that, you know, you can't consider this as the existence of an actual hostile relationship, but merely how the victim perceived it. And certainly that evidence was probative for the reasons stated in the cases that I cite in my brief, that it's important to create this context for the jury so that what happens in connection with the charges doesn't appear to them to be an inexplicable act of violence or, you know, a domestic abuse out of the blue, but instead paints a complete picture for the jury to help them contextualize that. Unless the panel has any questions on that, I'll rest on the remaining arguments in the brief.
All right, thank you both. This has been really well briefed, really well argued. I will mention, just because I got such experienced people, it's been 11 years since I was doing this. But we did this tradition that if you were going to mention a case that wasn't in your brief, you'd send an email to the other party, which is really helpful for us because then both parties are in it. So I would suggest. I mean, it's not a requirement, but it's a nice tradition from our perspective. But we're really grateful for the argument today. I'd also like to thank the court officer, our timekeeper. And of course, the clerk's office, which is always making everything run. And with all that said, court will be adjourned until April 1st.
Thank you.
Court, all rise. Court stands at recess.
That seemed like, that was easy.